Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today, back on the podcast, we have Mike Fielding, who is an attorney in Kansas City. Some of you may remember from earlier in the year, we had Mike on to talk about distressed farm debt and distressed farm loans and what can go on in those situations. Well, based on Mike's experience with many dairy producers getting letters based on the Dean Foods bankruptcy, looking for preferential payments to be returned to the bankruptcy estate, I had asked Mike if he wanted to come on to kind of explain what those letters mean and what you should be doing in those situations, especially if you've gotten one and this may be the first time you've ever seen one. They're not something, as Mike's going to talk about, to be taken lightly. Really happy to have Mike on the podcast today, and it's really great when we have experts come on and help explain these issues to me where it's something that I don't deal with in my ordinary day. So I'm going to turn it over to the pre-recorded interview. So I'd like to welcome back on the podcast Mike Fielding, who's a partner at Husch Blackwell or Husch Blackwell. I can't ever say that properly.
Husch Blackwell.
So thank you for coming on, and thank you for suggesting this topic when the demand letters came out. But we're going to talk today a little bit about preferential transfers and bankruptcy. And I know many dairy farmers have been sent letters by ASK. I don't know if it's ASK or ASK, but ASK, LLP, making certain demands, and I know there's time limits on this. So, Mike, if you want to go ahead and introduce yourself again to the audience.
Yeah, Paul, thanks for having me back on the show. I really appreciate it. My name is Mike Fielding. I'm a partner at the law firm of Husch Blackwell in Kansas City, Missouri. I'm in the food and agribusiness unit, and I really focus my practice on dealing with distressed agricultural related issues, insolvency related issues. We've seen these demand letters being sent out to the dairy producers and Dean Foods and candidly anybody else who was dealing with Dean Foods as well. And people are kind of scrambling. And so we thought this would be a good topic to discuss here today.
Yeah. So how about we get started with, we know many dairy producers have gotten these demand letters. So talking about preferential transfers or payments, what exactly is a preferential transfer or payment? Because this may be the first time many people have heard that term.
Sure. So to explain it, and this is really a product of Congress, right? So when people are listening to this and start rolling their eyes, just remember it's Congress that this is coming from. Okay, so we give that caveat, that disclaimer up front. But a preferential transfer is a payment that a debtor makes to, a creditor within 90 days of when the debtor files for bankruptcy. And it's a payment for goods or services that were provided. So for example, let's look at Dean Foods, because that's the one that's on a lot of people's minds right now. Dean Foods filed for bankruptcy on November 12th of 2019. And so there were a lot of producers supplying milk, other companies, trucking companies doing, trucking services, that sort of thing. They're providing these goods and services to Dean Foods. And so any payment that Dean Foods made to these producers between August 14th of 2019 to November 12th, that is considered a preferential payment. And what the bankruptcy code does, what Congress does, is it says debtors can go out and sue creditors for these monies to claw them back. And people say that's crazy because it was a legal transaction when it occurred. Yes, that's absolutely true. It was. It was a good faith transaction. It was an arm's length transaction. All of that is true. But the congressional rationale is that you may have a debtor who, prefers his friend Joe over here, but he doesn't like Sally. So he knows he's going to file for bankruptcy. And so he goes and pays, say, $100,000 to Joe, but doesn't pay anything to Sally. And Congress says, well, that's not fair because we want to have kind of this pro rata, this equitable distribution between creditors. And so what we're going to do is allow the debtor to go sue Joe, get the monies back, and then distribute it equally. That's the rationale for it. Now, does that happen in practice? No, what typically happens is the monies get avoided. A lot of it gets consumed by attorney's fees. And then, yes, there is going to be a pro rata distribution to creditors. But that is a preferential transfer in a nutshell, different from a constructively fraudulent conveyance. That's a discussion for another day. So we're going to focus on preferential transfers for today.
Yeah, that would be good. That would probably take up too much time if we went on down the other route.
Yep.
So thinking about preferential transfers or payments, and the letter lays this out, but what defenses should dairy producers be thinking about in some of these when they're getting one of these letters?
Yeah. So for listeners here, you need to understand that the way the bankruptcy code is set up, it's section 547 of the bankruptcy code. And it is section 547B, which is the debtor's claim, but then it's 547C that has a bunch of statutory defenses. And so we'll talk about, and that's where the vast majority of these matters are dealt with. And so there's 3 or 4 really common statutory defenses, and the benefit of each of these statutory defenses is that they can be combined. And so maybe I can use 2 of the defenses and really get some big, I get a better result than if I just use one or the other. So let's talk about those. So the first one, the first one is called the subsequent new value defense. And what that means is that if a preferential transfer payment is made and then the producer delivers something else after the fact, you get to essentially do a set off. And so let me give you an example. So let's say that going here on the dates, right? So we know the preference period is August 14th to November 12th. So if, if we had a payment, say on August 20th of $10,000, and then on, say, September 1st, the producer ships $7,000 of milk to Dean Foods, well, what you get to do is you get to count that $7,000 transfer as a set off against that $10,000 payment. So the net preference in that scenario would be $3,000. So that's the defense in a nutshell. Now there's the problem with it is the statute is really worded in a really funky manner, and it's not as easy as I've just given you the basic concept to generally understand it. But when you get into a lot of transactions, which is really common in dairy type situations, or frankly, in a lot of transactions, there's a lot of goods going back and forth. It gets complicated when you're interacting it with what is the next defense, ordinary course. So let me talk about ordinary course. Now, there are really what I call 2 different ordinary course defenses. The first one is subjective ordinary course, and the second one is objective ordinary course. So let me talk about how each of these play out. The subjective ordinary course defense, it looks at what the parties were doing in the preference period compared to their historical dealings. And so let me give you an example. Let's assume that you had a dairy producer and they were, delivering milk, and I'm just making up numbers here. Let's assume that the average days to pay in this pre-preference period was 25 days, okay? Then what you would do is you would look in the preference period, and what is common is they will take a protective window on that 25-day average, excuse me. And what you would do is, let's say that protective window is 7 days. So 7 days plus minus 25 is going to be 18 to 32. And so what the ordinary course defense would say, the subjective ordinary course defense is that, on average, we were getting these payments on 25 days. We realize some payments come early, some payments come late. That's why you get an average. That's the reason we're going to create this protective window, 7 days plus minus. And so anything falling between 18 to 32 days is going to be protected. But if something that is outside of that range, then it's not protected. And so let me back this up. So when we combine like the subjective and ordinary course defense, what we do is we want to first identify what is that protected range, and then that's going to be protected by ordinary course. And then anything outside of that protected range, we hope that there's some subsequent new value that can act as a set off to that defense. And that's how you can combine the defenses to try to minimize the exposure. So that's the subject of ordinary course defense. Now, the key thing is, like, if somebody was demanding payment or taking steps to get paid, what law firms like Ask will do is they'll say, well, that wasn't in the ordinary course defense, and that's outside of the ordinary course defense, therefore your defense doesn't apply. So there's kind of this give and take. Mm. The next defense is what I call object of ordinary course defense. And what the object of ordinary course defense says is, we really don't care what was happening in the parties' dealings in the pre-preference period. All we care about is what is happening in this 90-day period and whether or not those payments were ordinary for the industry in which the producer is operating. And so to do that, what you have to do is you look at industry standards and say, is this within a realm of reasonableness, a range of reasonableness? And if it is, it's going to be protected by the ordinary course, the object of ordinary course defense. And so you can see, in a perfect world, you'll combine all three, right? We've talked about subsequent new value. You'd want to protect some with subjective ordinary course, maybe some with objective. I've had cases where the subjective ordinary course defense protected some transactions, but then the objective ordinary course defense protected other transactions, that they were a little bit of outliers. And then you just combine the defenses and you're trying to minimize the exposure. And then the final one is contemporaneous exchange defense. And that's basically, it's just like it says, right? We intend to essentially roughly simultaneously give cash for goods, right? 3, 4, 5 days, whatever your dealings may be. But if it's roughly contemporaneous, then you can do it. So those are the defenses in a nutshell. The key thing to remember on these defenses is that it is the defendant, the producer, the creditor. They have the burden of proving these things. And that's why people getting the demand letters, Ask, I've dealt with Ask a lot over the years, me representing a lot of different creditors. Ask, obviously, they prosecute a lot of these actions. And Ask, when they send out their demand letters, they will always factor in a new value analysis, but they don't factor in the ordinary course defense. And that's really where it falls on your shoulder. Now, here's a little caveat for producers, because I see this a lot with clients, especially people that haven't dealt with these preference actions before. And they'll say, well, this was all ordinary course. And the problem is, it's a bit of a kind of a self-bias that they have of saying, well, of course this is ordinary. I think it's ordinary, therefore it must be ordinary, therefore go away. It doesn't work that way. Just because, this will sound really bad, just because you think you're pretty when you look in the mirror doesn't think other people think you're pretty, right? And I know that sounds terrible for me to say that, but there is a truth to that, in the sense of, when you may be looking at it and you may say, yeah, I think this is ordinary, but a judge or somebody that's really kind of objective may look at it and say, nah, that really isn't ordinary. So we need to be careful about that we don't drink our own Kool-Aid.
I think that's the best advice I've heard at any point on this podcast. Is sometimes you're just not pretty. You need somebody to come in critically and point that out to you.
I was a brutal gem of wisdom, huh?
So I think that kind of leads into the next thing, because what you're kind of hitting at is, if a dairy producer has gotten one of these, this may be the first time they've ever gotten a letter like this. What should they be doing? It's probably not handling this by themselves.
That's right. I think the worst thing that a producer or creditor can do when they get these demand letters is to ignore it. And again, to give another analogy, it's like ignoring a tumor, a lump that you've got. Okay, you don't ignore signs of cancer, right? And because we all know that the longer you ignore that, the more problems that you get. And the same is true as when you get a demand letter. Now, at the same time, you don't capitulate and they send a demand and you just don't open up your wallet, say, fine, take everything. No, what you want to do is you want to respond, let them know, yeah, I've gotten the letter. And then you need to contact an attorney and start seeing what defenses that you have. Now, let me pause. Let's talk about the people that ignore the demand letters, because they'll say, they look at it and they say, I've got ordinary course, and they should just realize that I have an ordinary course. Or, oh, this isn't fair. This feels like legal extortion, right? Because I've had a lot of clients use that before. And I get that. I know it feels that way. I mean, legally speaking, it is not extortion. It is a debtor using a statute that Congress has enacted. It definitely feels unfair. I get that. I really do, because I've dealt with a lot of people in that situation. But if you ignore it, what will happen is ask, or whoever else may be sending out a demand letter, they will file a lawsuit. And because this is in bankruptcy court, you get nationwide jurisdiction, and they just have to mail the complaint to you. They don't even have to send somebody to serve the summons. So they'll file the complaint, they will send the summons, and then if you ignore it, they will eventually move to get a default judgment. And so you may have had a complete defense, or maybe not a complete defense, a very good defense, right? But then it's one thing to have that defense, but it's another thing to ignore it and now suddenly be having a default judgment for the full amount. And you don't want to do that. So don't ignore it. You need to contact an attorney and really start getting some advice on this.
Yeah, I think that's probably the best advice, is just get an attorney, because default judgments are not fun to deal with.
No, you don't want to deal with that. Right. That's right.
And then, if they're working to get the attorney, they probably need to get some documentation together. What should they be getting together to prepare to take to an attorney to look at these demand letters?
Okay, so when you're, and let me give you a little caveat on the attorney too, what type of an attorney, because I think that's important as well. There's folks like me who, when you're dealing with bankruptcy law, because it's federal law, I've dealt with preferential transfers around the country for years, all right? And it is a very niche kind of practice area. There's subtleties to these defenses. I've given a good high-level overview, but when you drill down into the weeds, like anything else in life, there's nuances. And it's, just like being a good cattle producers, right? There's these small little things that you do that really can make a big difference. It's the same thing in a preference defense. And so, a lot of the producers typically live in rural areas, and those areas are serviced by attorneys who tend to be more generalist in nature. They'll focus on estate planning, divorce, maybe small business, but they don't deal that much with bankruptcy related issues. And so you want to find an attorney that is more involved in, it's an area of an expertise, and you want to go to somebody who really focuses their practice, or has a lot of experience, I should say, in dealing with this stuff. And the benefit is, you can go nationwide because it is federal law, and by and large, the law is generally the same, and a really good attorney will actually know the difference between federal circuits. So, but I digress. So let's get to your big question, which is what does the producer need to be rounding up as to make this to help with the preference defense? What I recommend clients do, the first and foremost thing is they need to come up with the payment history. Ideally, you would want to get a 15-month payment history. So for example, if you're dealing with the Dean Foods preference action, right, we know that preference, the bankruptcy petition date was November 12th of 2019. So we want to go at least 15 months back in time. So you're going to go all the way back to, about August of 2018 or earlier if possible, because we want to find out what the parties' dealings were over some period of time to see if there is an ordinary course defense. And so when we're asking for a payment history, what does that mean? Well, you want to look at the invoices that were submitted, basic information, invoice number, invoice date, what was the invoice amount, when was it paid, how much was paid, that sort of thing. What were the payment terms? Those are all key issues that you can get. And if you can get it into an Excel spreadsheet, it's going to greatly facilitate the analysis. You also need to identify unpaid invoices. So, it's very common that, especially as you're getting closer to bankruptcy, a producer is providing goods or services and then the debtor just stiffs them. That's really frustrating, but those unpaid invoices are going to factor into that subsequent new value defense that I mentioned earlier. So you want to round that up, do all the hard legwork of getting this data and give it to the attorney in an easy to use format, because that's going to minimize the attorney time spent on it so that the attorney can focus on analyzing the defenses. That is the most important thing. Some other information. You want to find out what your NAICS number, that's your North American Industry Classification code that the government puts out. The reason that's important is because if you can identify your industry classification code, there are published, you got to pay fees for these things, but there's different data sources that you can find out what are kind of common or ordinary terms for the industry as a whole. And so you want to, getting that information is helpful to trying to unlock the door to that objective ordinary course defense that I mentioned earlier. If you had any contracts that were in place with the debtor, get a copy of those contracts to the attorney. If the contract was assumed in bankruptcy as part of an executory contract, that's really important for the attorney to know. And then if you filed a proof of claim against the debtor, the attorney also needs to know that. One other item that is very helpful is if the producer provided goods post-petition and was not paid for them, there may be a set-off defense. It's a novel argument. I had a case of first impression. Full disclosure, I won. I know that's self-aggrandizing, but I was really happy about it. I'm not going to kid. Where we had that very issue a few years ago out in Delaware, it was a company had provided goods post-petition. They were not paid. They got sued for a very large preference action, about $13 million. We had our various defenses, but one of the defenses we asserted was saying that these unpaid post-petition invoices could be used as a set-off defense. The judge entered an opinion ruling in our favor. So it's, when you're going into these preference actions, you're trying to minimize your exposure.
That makes sense. And kind of one last question, you kind of talked about the type of attorney, but would it be wise for producers, if they're in an area together, to pool up and try to find one attorney together and work together to make it easier on, say, an attorney like you who's got, because it would seem like in a lot of cases, a lot of the information might be different, but a lot of the claims and defenses would be the same.
Yeah. There is definitely some truth to that. And one of the things is, because I've dealt with these preference actions, since the mid 2000s. And one of the things that I have learned is, a lot of times when you get these big bankruptcies, we'll be contacted by multiple clients who get sued or, demand letters. And what happens is when an attorney is representing multiple clients, the attorney tends to get a much broader perspective of the case, and they see what the debtor is doing and what they're not doing, because it's different. Sometimes there's cases where debtors will be more willing to compromise on certain points, and other times they're not. And having an attorney involved, not only you get some economies of scale, obviously at the end of the day, you got to look at each individual case. And so you can't, that will be what it is. But this broad picture perspective can be immensely helpful in trying to minimize the costs, and also get a big global perspective so that you can try to go at this most efficiently as possible. And so let me give a couple points here in this regard that's really practical to think about. One thing is, when a lot of times some attorneys, they look at these preference actions and they say, you've got a complete defense. We're going to just argue it. We're going to show that we're right. Well, that's good, but it ignores the other half of the equation, which is the attorney's fees. And I have long been a believer that I do my clients the best service if I am minimizing the overall cash outlay. So that's settlement amount plus attorney's fees. And if a producer is being faced with this, you want to find an attorney that really gets that concept and is going to work efficiently to resolve it quickly, but also at the same time to try to keep the attorney's fees down, because it doesn't do you any good. Another thing is, you want to look at, this goes back to the type of attorney involved, and I apologize if I talk too much about myself, but it's just something I've found is extremely helpful. Years ago, there was a couple up in Nebraska, and they had livestock. They were sued in the farmland bankruptcy, if people remember that, way back from the early 2000s, mid 2000s. And they were sued for like about a $70,000 preference action. And I remember, talking on the phone with the wife about it. She contacted our firm. She was obviously really emotionally distressed. It was a lot of money for them. And as I was listening to her, I just kept thinking there's got to be an efficient way to defend these things. And that actually started a process that went on for, I don't know, probably 10, 13, 14 years, of where I started developing a computer program, we call it Pref Defend, that analyzes this data. And so because I realized that if we take the data, like I said earlier, in the spreadsheet, and if you just dump it in, you can do the computer analytics and then instantly know what your results are going to be. And so that's what I worked on building. And it's been an incredibly good product. And because when we talk about minimizing attorney's fees, you want a sophisticated analysis. But unlike other legal issues that are so fact intensive, this is really data driven. It's a really unique aspect of the law. And so what I've been able to do is build this computer program to where we take the data, dump it in. It immediately spits out the results. I get about 400 different analytical results. It's got real-time what if analytics. So I change key variables. We talked about that window, like that protective window. What if you expand it? What if you shrink it? How does that change your exposure? I just have to change those numbers, and the computer automatically instantly calculates that. It generates a graph so I can visually see what was happening with the payment history. It's got a proprietary forecasting model that anticipates settlement. Again, that's a weather report. Sometimes it's really accurate. Sometimes it's not as accurate. Yeah. But, the point here is you want to harness the leverage, the technology that you have, because that's going to minimize your fees. And at the same time, you're trying to combine and minimize the exposure that you have, so that when you're going back to ask and trying to resolve the case, you want to be putting your best foot forward. So, and I'm not saying people need to engage me. There's a lot of very good, competent attorneys throughout the country that deal with these preference actions. My point, though, is this: these preference actions typically, unfortunately, it's rare that you just get somebody to drop the claim. Okay, and so it's just like a cancer. It's like, yes, I wish the lump wasn't there. Yes, I wish it would go away. But unfortunately, you've got to go to the doctor, and you may have to have a procedure to get it removed. And that's the same with these preference actions. You need to go see an attorney. You need to say, how can we minimize the exposure here, right? And that will probably require doing a settlement offer of some sort. But you want to get that as low as possible, put your best foot forward, and then you make the settlement, and then you get it resolved and you move on. And so just like you maybe have to have a surgery to remove something, yes, it's painful, but yes, once it's done, it's done. And unlike cancer, where there's the risk of it coming back, you don't have that with the preference. Once you're done, you're done.
That's good advice. So any additional parting thoughts?
I've given a lot here.
You have.
I guess I'll just say up front, my reference earlier about looking in the mirror and thinking you're pretty, I genuinely apologize if my intent is not to offend anybody. And that is probably a poor analogy that will haunt me in the future. But my point was that sometimes we have this self-serving bias that we tend to look at something in the most favorable light, and others may not have that same appreciation that we may have. And unfortunately, it's those other people that are judging us. So we have to look at it from their perspective, not necessarily our perspective. So again, I'm going to apologize up front on that one. But it serves an important point and an illustrative.
It does. Well, thank you for coming on again today. And it's always a pleasure having you on.
Yeah, happy to be on, Paul. Happy to talk in the future if needed. Thanks.
Thank you again for listening to this episode. If you have any questions or any thoughts on future episodes, please email me at lgoering@umd.edu. If you have questions for Mike specifically, I'm going to put Mike's contact info in the show notes so you can get in touch with Mike. I'll at least get his firm bio page up there so you can find out how to get in touch with him, specifically if you have more questions. But thank you again for listening, and enjoy the rest of your day.